Well, good afternoon, everybody, and welcome to the second part of Landmark Chambers' series of webinars entitled Property in Quarantine. My name is David Nichols, and together with my colleague David Holland QC, we will be speaking to you this afternoon. Some of you may already have enjoyed the regulation of the private rented sector in England earlier this month. Now it is time for our programme entitled Liquidation Foundation, an introductory series of 4 webinars providing essential insolvency knowledge for property practitioners with little or no insolvency experience. Just a couple of housekeeping matters before I get underway. Microphones should be automatically on mute, as should your videos, but do please double check. You're very welcome to post questions through the chat facility, and we intend to collate all the questions at the end of the entire series next Wednesday, and then supply answers through a paper that will be published on our website. The seminar is being recorded and will be uploaded to the website, and if any of you lose connection, then please do come back in by clicking on the original link, and further supplemental papers will be provided at the end of the series as well. Today we begin with some introductory concepts. The series will continue tomorrow at the same time with a focus on landlords with insolvent corporate tenants. And next week on Tuesday, you can enjoy the rather morbid sounding end of life, dissolution and restoration before we conclude next Wednesday, the 27th of May, with a focus on property issues in relation to bankruptcy. So returning to today, I will speak for about 15 minutes covering the following topics. What is insolvency? Why is it important? What are the main types of insolvency process? What are the key features of liquidation and also administration? And David Holland will then speak for about 15 minutes, focusing on bankruptcy and voluntary arrangements. So what is insolvency? Well, insolvency is the inability to pay one's debts. That sounds easy enough. That's a concept we will recognize. Income's your salary every month, paid on the left-hand side of the screen in those nice green banknotes, and out on the other side, weighing down the scales, go all those bills. Income is, as we sometimes know, income is sometimes exceeded by the outgoings. Now, who is that inquisitive fellow in the corner in his top hat? Well, surely we all remember Mr. Micawber's wise words in David Copperfield. Annual income £20, annual expenditure 1919 and 6, result happiness. Annual income £20, annual expenditure £20 naught and 6, result misery. Well, expenditure exceeding income may result in misery, but it is not a civil or criminal offence to be insolvent. The legal consequences only arise once some formal insolvency proceeding commences. Now, in relation to corporate insolvency, a company may be insolvent in 2 circumstances. First, if it is unable to pay its debts as they fall due, this is known as the cash flow test. And secondly, if the company's assets are insufficient to discharge its liabilities, this is known as the balance sheet or asset test. When a debtor fails to pay a debt, the creditor is ordinarily entitled to avail himself of all the rights and remedies given to him by his contract and by the law. In contrast, the primary purpose of insolvency law is to replace that free-for-all of individual claims by different creditors with a statutory regime in which creditors are dealt with collectively. Their rights and remedies are suspended, wholly or in part, and there is a mechanism for the orderly collection and realisation of assets and for their distribution amongst the creditors. The central principle of that distribution is the pari passu principle, the idea that unsecured creditors should share in the assets ratably according to the quantity of their debts, although very often there are few assets left for ordinary unsecured creditors to which the principle can be applied. Another key feature of the modern law of insolvency is the rescue culture. In the early 1980s, there was a review of insolvency legislation by Sir Kenneth Cork, which led to the Cork Report and the advent of the principal source of insolvency law today, the Insolvency Act 1986, and what were then the Insolvency Rules 1986, now largely written in 2016. And as a result of the Cork report, the modern policy of UK insolvency law has been to attempt to rescue a company that is in difficulty, to minimise losses and to fairly distribute the burdens that result from enterprise failure. But if a company cannot be saved, it will go into liquidation. Now, I asked the question, why is insolvency important? Well, first of all, as a practitioner, as an area of law, there is a fascinating mix of complex statutory provisions. Indeed, the Insolvency Act and the rules have been described as, and I'm quoting, a legislative morass through which even the most experienced practitioner cannot pick his way without difficulty. So it's a mix of statute and fundamental questions concerning the distinction between real and personal rights and the extent to which creditors have a legally protectable interest in the proper application of the company's assets. In my view, an understanding of corporate insolvency law requires a true perception of the principles of the general law of property and obligations and the interrelation of these and insolvency legislation. Now, it's also important to put the present situation into its recent historical context. Here you can see a 10-year view of the trend in liquidations between 2003 and 2013. And what you can see right in the middle of that is that peak on the black line in around 2009 that was caused by the financial crisis. And the rate remained higher after the crisis than it was before. And the numbers on the left are in the thousands. So there was in that period of time between 3,000 and 5,000 liquidations per quarter. Now, if we look at the next slide, this takes a much longer perspective. Here you can see, I think it starts in about 1985 and goes through to 2013. And the really big peak here in liquidations, which is shown in the blue line, is around 1993, the recession of the early 1990s. And I appreciate that perhaps some of you listening probably weren't even born then. But if we then look, where is that peak I showed on the previous slide, the peak in 2010, it barely appears as a little bump on the right-hand side. So you can see the way in which liquidations there have changed, but contrast that with the red line, which shows the individual insolvency rate as a result of legislative changes in the early part of the century. Bankruptcy and IVAs became much easier. This graph shows the current position over the past 15 or 16 months or so from the beginning of 2019, and what you see here is more or less a consistent approach on a per month basis at around, at the moment, about 1,200 liquidations per month. That would be about 3,600 per quarter. Now, of course, we also have the consequences of COVID-19 and the lockdown. It's probably too early to say with certainty what the precise consequences will be, but even before coronavirus, what the precise, most insolvency experts were already predicting a rise in corporate insolvencies during 2020, caused by the slowdown last year. That slowdown will be hugely exacerbated by COVID-19, and many Western economies are likely to go into recession. And an increase in insolvency will have an effect on real estate. Even this morning, the headlines included future of corporate headquarters in doubt, Café Rouge appoints restructuring firm for a possible CVA, landlords lose millions from Kidston collapse, and so on. But what will the future of insolvency be? Will it be the same or will it be different? And I think there may be changes as a result of a response to COVID-19. There have been various government announcements proposing reforms to the insolvency framework. These include a temporary suspension of wrongful trading legislation, a new moratorium of 28 days prior to administration or liquidation to enable a rescue or restructure, prohibition on suppliers enforcing termination clauses in contracts, possible new restructuring vehicles, a moratorium on lease termination for non-payment of rent. But as far as I'm aware, there's no new legislation yet introduced. The government's promised to introduce restrictions on the use of statutory demands and winding up petitions to recover sums owed by tenants, but the new legislation has not yet been laid before Parliament. And it's not clear whether it will be of general application or specifically for tenants. And there may also be legislation to provide tenants with more breathing space to pay rent by preventing landlords from using CRA unless they are owed 90 days of unpaid rent rather than 7 days. So considering the different types of insolvency process, there are several different processes. For individuals, there's bankruptcy, about which David Holland is going to speak shortly, and he'll also speak about the concept of a voluntary arrangement or composition with creditors that applies in both the corporate and the personal context. The other principal insolvency processes for companies are administration and liquidation. And liquidation comprises a number of different types: compulsory liquidation, members or creditors, voluntary liquidation. Each of these different processes has certain basic objectives in the corporate environment. The first objective, which is realized in only a small number of cases, is restoring the company to profitable trading, usually within a CVA, but sometimes also in administration, part of the rescue culture that I mentioned a few minutes ago. And the primary purpose of administrations and voluntary arrangements is to achieve a restructuring and a reorganization where the business is fundamentally sound and has good prospects of being restored to profitability. It's important to bear in mind, though, that the fate of most solvent companies is winding up, but not every insolvency leads to liquidation. And in our current situation, there will doubtlessly be many sound businesses that have become insolvent as a result of COVID-19, and therefore an insolvency process of rescue will be the best way forward. But for others, COVID-19 will simply brought to the fore the fundamental structural problems in those businesses so that a rescue is impossible. Another objective is to maximize returns to creditors. This may be achieved by ensuring that assets are not removed from the reach of creditors in the lead up to insolvency. It's an objective that reflects the collective nature of the insolvency process. And finally, there are the objectives of identifying causes of failure and addressing mismanagement, which are important because they're intended to help ensure there's no repetition of the causes of failure. Turning then to administration, this was a process first introduced in 1986, following the recommendation of the Court Committee. It is a collective insolvency procedure designed to promote the rescue culture by placing the company's affairs in the hands of an administrator who is entrusted with the task of achieving a specified objective. And those objectives are set out in paragraph 3 of Schedule B1 to the Act. The first, rescuing the company as a going concern. Secondly, achieving a better result for the company's creditors as a whole, who would be likely if the company were wound up without first being in administration. And thirdly, realizing property in order to make a distribution to one or more secured or preferential creditors. It's possible for an administrator to be appointed out of court by the holder of a floating charge or by the directors, or an application to the court. And if there's an application, the court must be satisfied that the company is or is likely to be unable to pay its debts, and that there is a reasonable likelihood of achieving one of the 3 objectives mentioned. An important feature of administration is the statutory moratorium. Thus, while the company is in administration, the collective nature of the insolvency process is demonstrated by the fact that other creditors are not permitted to take any action against the company. Thus, no winding up, no enforcement of security, no repossession of goods, no forfeiture, no legal process. Although for most of these, there is the possibility of proceeding if you can get the administrator's consent or the permission of the court, but those are far from automatic. An administration usually lasts a year and ends either in rescue or in a better outcome for creditors. But unless the company is rescued, the company will move into liquidation and then be dissolved. And the 3rd seminar in this series will consider the consequences of dissolution. And then we have liquidation. Liquidation or winding up is a collective insolvency process leading to the end of the company's existence through dissolution. The principal role of the liquidator is not to try and rescue the business. It is to collect in and realize the assets, to ascertain claims, to investigate the causes of failure, and after covering the expenses of the liquidation, to distribute the net proceeds by way of a dividend to creditors. The liquidator has no power to carry on the business of the company in order to rescue it. And there are several different types of liquidation. The members of a company may voluntarily put the company into liquidation. If the company is solvent, this is known as members' voluntary liquidation. If the company is insolvent, then this is known as creditors' voluntary liquidation, because even though it is affected by the members of the company, it's the creditors and not the court who have control of the liquidation. Most familiar, of course, is compulsory liquidation, where the company, a director or a creditor, petitions the court for the company to be wound up. There's no need for a statutory demand, but the debt must not be disputed. It's a formal process closely controlled by the court, and the official receiver becomes the liquidator unless and until an outside liquidator is appointed. Creditors must prove for their debts, which are paid out if there are funds to do so, in a specified order of priority. The liquidator has statutory powers to investigate antecedent transactions, such as preferences or transactions at an undervalue. Once a winding up order is made, it is deemed to have commenced at the time of presentation of the petition or on the passing of a resolution for voluntary winding up. In either case, this retrospective effect may have consequences in relation to dispositions made by the company and the investigation of antecedent transactions. Once the order is made, no action may be proceeded with or commenced against the company except with the leave of the court. Control of the asset passes to the official receiver as the initial liquidator. The appointment and powers of the directors are terminated, and the order operates as a notice discharging employees. And finally, I just conclude with a short summary of some of the differences between administration and liquidation, the former tending to be a cheaper process, the focus on rescue, the administrator running the business to achieve that better return. In conclusion, I hope I've given you a basic introduction to the concept of insolvency, a little bit of its history, its current significance, and the main features of the most common types of corporate insolvency process, administration and liquidation. And I'll now hand over to David Holland, QC.
Good afternoon, everybody. Excellent. I hope you can now see the slides on the screen. I'm going to talk a little about bankruptcy and then voluntary arrangements. It really is a very basic outline sketch. It's Bankruptcy 101, although I suspect by the time I finish speaking, you will feel you've been in room 101. We start with bankruptcy. What is bankruptcy? Well, it's a statutory mechanism, and it's a way of rehabilitating an insolvent individual as opposed to a company or a partnership. And it provides for the automatic discharge from debts predating the bankruptcy. It's also a way of providing for an independent third party in the form of an insolvency practitioner to collect the bankrupt's assets, investigate his affairs, and distribute the estate among those creditors entitled to it. It's a purely statutory procedure, and it's now governed by parts 8 to 11 of the Insolvency Act 1986. Just get this over here. Sorry. There you go. What are the consequences? Sorry about that. Consequences of a bankruptcy order. Well, the effect of a bankruptcy order is automatically to vest all property belonging to or vested in the bankrupt at the commencement of the bankruptcy, in the official referee, receiver, and then in the trustee on the making of the bankruptcy order. Where a person is made bankrupt, any disposition of property made by that person after presentation of the petition is void unless it's ratified by the court. After a petition is presented, the court may stay any action, execution, or legal process against the property or the debtor. Once an order is made, no person who's a creditor in respect of a provable debt can have any remedy against the property or person of the bankrupt, and before discharge, they cannot commence any action or legal proceeding without consent from the court. The creditors are then limited to proving in the bankruptcy for the dividend, and that's part of the pari passu principle that David has already told you about. How long does a bankruptcy order last? Well, it starts with the day on which the order is made and lasts until the individual is discharged, which occurs automatically at the end of 1 year, beginning with the date on which the bankruptcy commences. The court can extend that period until the end of a specified period or a specified condition if the bankrupt has failed or is failing to comply with his obligations. That is normally where the bankruptcy is failing to cooperate with the trustee in the realisation of the assets. The effect of discharge is to release the bankrupt from all bankruptcy debts, but this has no effect on the functions of the trustee, and the provisions of the Insolvency Act for the trustee are to carry on with those functions. At a very high level, the bankruptcy debts are debts or liabilities which the bankrupt is subject to at the commencement of the bankruptcy, that's the date of the bankruptcy order, or which he may become subject to after the commencement of the bankruptcy by virtue of an obligation incurred before the commencement of the bankruptcy. How do you make someone bankrupt? Well, a petition can be presented by a creditor and certain other categories of person. There are 4 conditions for the debt in respect of which a petition must be presented. It must equal or exceed £5,000. It must be liquidated. It must be payable immediately or at some certain future time, and it must be unsecured. So far as liquidated is concerned, this means a debt which is ascertained or ascertainable by some contractual formula or machinery. So, for example, solicitors' fees, which are untaxed or unagreed, cannot be made is not a bankruptcy debt, or service charges, which are not fixed by a contractual formula, cannot be a bankruptcy debt. However, rent and a guarantee liability, which is ascertained, that can be. The debtor must be unable to pay or have no reasonable prospect of being able to pay. And that means essentially that the creditor has served a document called a statutory demand on the debtor. 3 weeks have elapsed, and the statutory demand has neither been set aside, nor has the debt been paid, secured, compounded for. So if an alleged debtor disputes the debt, says it's not owing, then he has to apply to set aside the statutory demand. The court will not make a bankruptcy order unless it's satisfied that the debt is one which was payable at the date of presentation or has since become payable and has neither been paid nor secured nor compounded for, or there is reasonable prospect of it being paid when it falls due. The court can dismiss the petition if it's satisfied the debtor is able to pay all the debts, or is satisfied the debtor has made an offer to secure or compound the debt and the creditor has unreasonably refused the offer. Oops. Can an order be challenged? Well, save for the usual ways that you can appeal an order of the court, a bankruptcy order can either be annulled or rescinded. Annulment is discretionary, and there are essentially 2 bases upon which a court can exercise its discretion. If, on grounds existing at the time when the order was made, it is satisfied that the order ought not to have been made, or if the bankruptcy debts and expenses have all been paid or secured to the satisfaction of the court. The court can annul whether or not the bankrupt has been discharged, and the effect is that the bankrupt's estate will revert to the bankrupt on such terms as the court may direct, subject to any sale or disposition being held valid. Rescission is also discretionary. It will be exercised only in exceptional circumstances, particularly where there are events which have occurred since the original court order is made, or whether facts which were not brought to the attention of the court when the original order was made. How does a bankruptcy affect the landlord and tenant relationship? Well, after a bankruptcy order, the landlord cannot issue a money claim for payment of rent or any other type of proceedings claiming a provable debt without leave of the court. The landlord can issue proceedings for forfeiture, including on the grounds for arrears of rent. The landlord can peaceably re-enter if that right is otherwise available. CRAR is exercisable, but only for up to 6 months' rent before the commencement. And similarly, the landlord can go against the subtenant for the tenant's rent, but only if CRAR is otherwise exercisable. That's a quick sketch of bankruptcy, it really is, and further detail will be provided in subsequent talks. I'll now look at voluntary arrangements. What is a voluntary arrangement? Well, there are 2 different types, unsurprisingly. One is a company voluntary arrangement, or CVA for companies. The other is an individual voluntary arrangement, or IVA for individuals. A voluntary arrangement is essentially a statutorily recognised binding agreement between a company or an individual and its or his creditor, unsecured creditors, whereby the debtor agrees to pay and the creditors are bound to accept a lesser sum over a longer period than the creditors might otherwise be able to claim. The concept of the voluntary arrangement for companies was introduced by the Insolvency Act 1986 after the Cork report, which David has alluded to. There was previously a circumstance in which a bankrupt, an individual, could compound with his creditors. Now, the aim of a voluntary arrangement is part of the rescue culture. It is, one, to find a binding solution with creditors for the debtor who could not otherwise pay; two, to avoid the debtor going into formal insolvency; and three, to attempt to get a better solution for the creditors than would otherwise occur or otherwise result from formal insolvency. 3/4 of the creditors by value can bind the minority creditors into such an arrangement, even if the latter did not consent. The arrangement then effects a valid compromise of the debts subject to the voluntary arrangement. How does it work? Well, the directors or the individual has the burden has the burden of taking the initiative in setting up the voluntary arrangement. If the company is in administration or liquidation, the office holder may make a proposal. A proposal is formulated and then voted on by creditors, and in the case of the company, also its members. The key here, as I said, is that 75% by value of the creditors, if they vote in favour, they can bind the minority creditors, even if the latter object, and that 75% must include 50% of unconnected creditors. If the proposal is accepted, the scheme becomes binding on the debtor and all of the creditors, as I've said, even the dissenting minority. A supervisor then administers the voluntary arrangement. The supervisor will hold the funds collected on trust for the creditors entitled under the arrangement, but unlike in bankruptcy, the property of the company individual does not vest in the supervisor. The court oversees the arrangement in that creditors and the supervisor can apply to the court for directions or to replace the supervisor. What are the consequences for creditors and for other contractual arrangements? Well, if the voluntary arrangement is approved, it takes effect as if made at the time the creditors decided to approve it. The voluntary arrangement binds every person in accordance with the rules who, in accordance with the rules, was entitled to vote or would have been entitled if he had a notice of the decision procedure. That is, every creditor, secured or unsecured, who has notice of the decision procedure and is entitled to vote in respect of that creditor's debt. They are entitled to vote in accordance with the amount of their claim. If the claim is unliquidated or unascertained, the creditor can vote if the chair or convener, usually the supervisor to be, gives the debt an estimated minimum value for the purposes of entitlement to vote. It'll be estimated at £1 unless the chair or convener decides to put a higher value on it. The voluntary arrangement is a statutory contract, so what its consequences are, save for binding the creditors, depends on the construction of the individual voluntary arrangement. It can compromise future debts, but this would again depend on the wording of the individual voluntary arrangement. A voluntary arrangement cannot affect the rights of a secured creditor to enforce their security, except by that creditor expressly agreeing. How does one set one up? Well, the directors of the company may make a proposal to the company and to its creditors for a composition in satisfaction of the debtor or a scheme of arrangement of its affairs. Likewise, an individual who is an undischarged bankrupt or would be able to make a bankruptcy application can make a proposal. The proposal will provide for a qualified insolvency practitioner to act as nominee in relation to the voluntary arrangement, either as trustee or otherwise for the purpose of supervising the voluntary arrangement. The nominee will then make a report to the court within 28 days for companies or 14 days for individuals of being given notice of the proposal. The report will state whether the voluntary arrangement has a reasonable prospect of being approved and implemented, and whether it should be considered at a meeting of creditors and of the company if it's CVA. If the nominee thinks the proposal should be considered, they must seek a decision from the creditors and the company. Where the creditors are asked to decide, they can approve the voluntary arrangement, approve it with or without modifications. Similarly, the company itself. After the decision procedure in a CVA, the nominee must report the decision of the creditors and the company to the court, and immediately after reporting, give notice to certain prescribed types of person. Similarly, with individuals, notice must be given to certain prescribed types of person. Now, a moratorium can be obtained for certain companies when directors intend to propose a voluntary arrangement. That's section 1A of the Act, but that's a rarely used procedure. Similarly, an individual can get an interim order under section 252 of the 1986 Act, which prohibits a petition from being presented or proceeded with, prevents a landlord exercising a right of re-entry peaceably without leave of the court, and prohibits proceeding without the court's permission. Can it be challenged? Well, voluntary arrangements can be challenged on the basis either that the voluntary arrangement unfairly prejudices the interests of a creditor or a member or a contributory, and or that there has been some material irregularity in relation to the relevant qualifying decision procedure. The people who can challenge are those who were entitled to vote in the relevant qualifying decision procedure or meeting of the company, or would have been entitled had they had notice. Also the nominee, and if the company's been wound up or is in administration, the administrator or liquidator. The application must be made within 28 days beginning with the first day on which the reports to the court were made, or if the person making the application did not have notice of the decision procedure, within 28 days of the day he became aware of that decision. If the court is satisfied on either of the grounds, it can give one or more of a number of different orders or directions. It can revoke or suspend the decision approving the voluntary arrangement or any decision taken at a meeting or in the decision procedure. It can give a direction to summon a further company meeting to consider the revised proposal or reconsider the original proposal. It can direct any person to seek a decision from the company's creditors as to whether they approve a revised proposal. If the case is a material irregularity case, it can direct any person to seek a decision from the creditors as to whether they approve the original proposal. If satisfied that the person does not intend to make a revised proposal, the court can revoke an earlier direction to seek a decision on that proposal and revoke or suspend any decision approving the voluntary arrangement. The court can also give supplemental directions as it thinks fit, in particular with regard to things done in the voluntary arrangement since it took effect. If the voluntary arrangement is not challenged, a decision is not invalidated by any irregularity at or in relation to a meeting or in relation to a qualifying decision procedure. What are the consequences of a voluntary arrangement for the landlord and tenant relationship? Well, once a voluntary arrangement is in place and depending on its terms, CRAR would not be available for debts subject to a voluntary arrangement. The landlord cannot resort to subtenants because CRAR is not exercisable. The landlord is bound in respect of both past and future rent, again depending on the terms. However, the landlord's right of re-entry is unaffected. The last of these two propositions were set out in quite well-known case Discovery Northampton versus Debenhams, which will no doubt be discussed at a future talk. That's all I propose to say. It's a very brief overview. If anyone has any questions, then we no doubt like to see them on the Zoom chat function. We won't answer them now, I don't think, but what we will do is note the questions and seek to answer them, as David said, specifically in a paper following this. Thank you very much indeed for listening.